Hello, I'm Carla Mathers, and I work for the Marie Center, and I'm thrilled that I was invited to talk to you on this national symposium on video conferencing. My talk is about the mediated legal proceedings in video conferencing, remote interpreting. I will be talking to you about the history and the evolution of technology and how that's affected our interpreting and how technology has changed and influenced the legal interpreting process as a profession. If you remember, in 1994, in that year, Al Gore, the vice president at the time, invented the internet. Do you remember that? Do you remember the interpreting world at the time? In 1994, we were driving to very remote locations. Now it's 10 years later. In 2004, interpreting technology have merged, and there's new emerging video relay service where the interpreter's working and interpreting calls. Now 10 years later, in 2014, it's very different. We have video remote interpreting, which we call VRI. It's phone interpreting, however the calls are not coming in. You're actually meeting and interpreting for situations in hospitals and law proceedings as well. In 2024, I'm not so sure how interpreting and technology is going to be infused at that time. For now, I'm going to begin with a little bit of history in terms of technology in court and technology in interpreting in general. Now, in the courts, of course, there's theory and goals in interpreting, but the most important one is a fair process for every individual, which is due process that's afforded to people. And the courts do have concerns about how external people view a fair proceeding. And that's typically a concern in the courts. So if we have language barriers in this situation, spoken language versus sign language, and having a general understanding is that question, then it's not a fair proceeding. The courts are responsible to break any barriers. And we remove those barriers by providing interpreters through video interpreting, and that could be through video conferencing. And if that's not successful, then you actually bring in a live interpreter. You have to balance what's more efficient and effective versus cost, and whatever is fair for individuals involved. I'll also talk about the vocabulary. In the legal world, for years, we have used video conferencing for court, for hearing people as well. And we refer to that as video conferencing in court. So again, that's used for hearing people as well. Now, when I refer to video conferencing in interpreting, it's fairly new. But we're using spoken language interpreters and sign language interpreters. So I typically would say video remote interpreting in courts related to deaf people and interpreting versus video conferencing. So there's various settings as well. Through our research, it shows various setups and settings you can use this in. You can use it in court, where you have the deaf individual at one location and the interpreter at another location. That's 3 separate locations for the proceedings, which requires a lot more technology. We need a large screen that can have a couple of different screens within the large screen. In the United States, they oftentimes use in the executive office of immigration review, they do use that 3 location remote setup. They may also use, if a deaf individual is in prison and then there's a court and then there's a call center, that setup can also be used. Some research shows, and I'll explain this later, that it's not the most effective. when you have 3 separate locations. Now, another possible setup is at the court, when you have the deaf individual with the interpreter at a separate location. And it could be that the deaf person's in prison and the interpreter's at the prison itself, and the attorney is at the courthouse, and it's a separate location. However, the court does have some technology and experience for the bail review through video conferencing, the bail review hearings. So we use that technology that's already been set up to our advantage. Now, we may have a deaf individual at the courthouse, and I'm going to back up. We may have an interpreter actually at the courthouse and the deaf person at a different location. It's the same concept again with this possible bail review hearing. And in that situation, the interpreter may find themselves in a difficult situation. As an example, in Maryland, our county is that we have in the room, there's the judge sitting at the table, and if you have a deaf prisoner and if you want to use the interpreter at court, the interpreter has to actually sit in the judge's seat. So that's can be awkward because of the camera and where it is. It's a fixed camera that can't move. So that is an issue, one other additional issue related to technology. The next setup is in the interpreter that's in another room, and the deaf person is in the courtroom with the judge and the lawyer and attorney, and we use VRS. We traditionally see that the interpreter is at a call center. Some courts in the United States, for example, in Oregon, they have a staff interpreter that does video remote interpreting. They use a special room at the courthouse. And the concept is very typical to a call center, and what we see being used as VRS. So I'm going to talk briefly about the history as I did. Again, it's taking slow strides because we want to be careful that we don't exclude individuals and the changes in the courts that is happening. We want to assist people in this process. Technology has actually been in the courts for years, for a long time, and it didn't involve any interpreters. Everyone that was involved was hearing. Some court rulings were done through the phone if people couldn't make it in, and they have a very compelling reason not to be present. Then it was done over the phone. For any eyewitnesses, that was allowed. In some cases, like employment discrimination cases within the EEOC, the agency allowed telephone depositions to take place. And they've been doing that for years. So now with the additional interpreting process in place, it's not new to the court systems. They're very familiar with this process. So, like I've mentioned, they use telephones, and now if we use the interpreter with the phone system, typically it's done remotely, and with remote technology, we use telephone interpreters. People have suggested that the phone interpreters, again, if they can't find a qualified interpreter to be there in the room, they will use this type of technology. And businesses were established, but they weren't standardized. So there was no test for interpreter qualifications and so forth, and it was then used on a limited basis. However, since 2007, the United States federal courts had a telephone interpreting program, and 48 different courts used this particular program in 38 different languages. Now, in 2007, 3,600 different court cases and proceedings were actually done through the phone. So they calculated in 2008 how much money they saved. It was $6.8 million in savings because they use the phone interpreting system or through the phone. And there's cost savings, and it was also a very efficient method for the courts. Now then we have video conferencing. It's video conferencing in court. That was established in order to save money. If people couldn't be there in person, typically it was expensive to have the witness flown in and so forth. They used video conferencing technology. Also for the use of the prisoners. And I can't remember exactly when it was, but I think there was a Ted Kaczynski, the Unabomber, I believe it was. He was arrested in Montana. And then brought to California, in Sacramento, California, and was a prisoner there. But the charges were in New Jersey. So he had to attend the arraignment, which is a brief meeting to read him his rights and so forth. So he went to the arraignment in New Jersey. And the cost for actually bringing him to New Jersey was $30,000. They didn't actually bring him, and it only cost $45 to actually do this through video conferencing. So it's a money saver. For that specific, very short arraignment, it seemed more effective to do it this way. Video conferencing in court for the first time in Illinois began in 1972. They used it for arraignments, bail review hearings, and those were only two situations. And then it wasn't until 1982 in Florida, where the United States federal government started in 1996 writing rules for witnesses to be questioned through video conferencing technology. We use Skype in my courts for expert witnesses and so forth because it's $2,500 for somebody on a daily basis to come to the court and actually be present. So it's much cheaper to use video conferencing technology. So I want you to read this particular slide. The first sentence talks about the interpreters and the position. It's important to understand it doesn't mean where the interpreters are actually positioned physically, but it's a case decision on the role of interpreters. And this is from the International Conference for Video Remote Interpreting in Europe for 2011. Adviticus conference that took place in 2011. So before 2011, there was no case decided, but the point of this quote is that it's the government's responsibility to ensure that whatever interpreting services are being provided, that the services are effective and meets the needs of the people involved. Now I'd like to talk about video conferencing and interpreting. Currently in the United States, it's most often used in the EOIR office for immigration asylum processes. In Europe, actually, they had a variety of uses they use it for expert witnesses to question the suspect, the prisoners, and in immigration service as well. They use it for a broader range of services. This fall, in preparing for this presentation, I looked at LinkedIn, and in looking at one program or one particular page related to video remote interpreting, I found this quote, and I've used some of these quotes from LinkedIn, and you can see this. You can see the timeline, the companies, the medical remote interpreting, VRI. They have BIS. VRI has 100 clients. USA VRI also allows interpreters to work from home to build their own businesses. And as attorneys, I'm not so sure we're ready for court interpreters to work from home. But that possibly may be one of the topics you can assess and talk about with your colleagues through the symposium. And TCS VRI has 25,000 hours of interpreting for one contract. 25,000 minutes for this contract. So VRI is here. You should become involved, or people are going to run with it. If interpreters are not involved at this point, right now, you're going to lose an opportunity to be involved. We see that in the field of educational interpreting. We've seen that happen in video relay service interpreting. So the time is right. It's not the future. It is now. Now there are several pilots that have been established in projects, and one court system, or one or two systems, have full-time staff members who on a regular basis analyze and assess this service. I've already mentioned Oregon. They have a staff interpreter who assesses a situation to see if it needs video conferencing or if it needs a live interpreter. So they do also have a project where sometimes, because of distance, and California law actually requires the interpreter to be certified with SCL, they will contract with certain interpreters. SCL is Specialized Certificate Legal. So an SCL interpreter. So in Nebraska, they wrote a grant and got $80,000 for an individual to come in and set up all the technology and work with the various courthouses. And they also have a staff interpreter. They used to work all day. They used to drive and come back across the state. So it's much more efficient for that state to have the video remote interpreting provided. Texas also has a project for the domestic violence cases and Spanish interpreters, where they use these interpreters to file the paperwork and video conferencing technology through an interpreter as well for the domestic violence proceedings. Now, Legal Services Corporation on an annual basis provides money for technology initiatives and a technological initiative grant. This year they provided a grant for an interactive website for Spanish-speaking individuals. So there's iChat features all in Spanish, or interpreters that provide interpreting services. Also with Google translations as well. So interpreters know how effective or ineffective it may be to do this type of translation, but that's a grant and pilot program. We'll see how that works. Now, we currently are trying to establish video conferencing in courts in the United States. There are 14 different courts involved in this project where they're going to film live cases and proceedings in the U.S. federal court system. So you could actually stay home and watch live proceedings. It hasn't started just yet, but I was talking to one director of this project, and they have video conferencing taking place in court. And then they're going to study this, and then they're going to take a look at video remote interpreting processes. There's no rule related to VRI as of yet, but we're looking at federal rules on criminal procedures to see what they require. The defendant, if they're required to be there or if they can stay in video conference, that's more efficient depending on the rules. If they require the defendant to show up, then that would not be an appropriate situation to use VRI. So VRI is a possibility if the defendant stays. So there's rule number 43 says the defendant may have to show up to all of the trial for the more critical stages, from selecting the jury, from beginning the case, and then announcing the sentence or decision, and then the sentencing. There are several other federal rules that say if the defendant were to agree to do this remotely, that's fine. They can do this for the arraignment and for the status conferences. That's allowable. If they agree, if they do want to be there, then they will be brought to the actual courthouse. There's only one case that I've seen related to VRI, which is an immigration case, RURS, and you have information on your PowerPoint. You can see the particular case number, and you can refer to that. RUSU is related to the asylum court ruling, which means that if somebody lives in another country and wants to stay in the United States, because if they go home, they'll get killed or tortured, or they have some extreme case and they have a compelling case to stay. This ruling says, well, their goal is to convince a judge to allow them to stay in the United States. However, if they do through this video conferencing system, they don't feel like they can trust, and they're not as credible, or there's enough credibility in this because they can't see them, they can't hear their breaths, see their face, that there's something missing from this. So the RURS, unfortunately in this particular situation, sent them back home, and they were not allowed to stay. The American Bar Association in 2012 established an advisory committee to give advice referring to language access. So I am a member of that committee, and there are several things that we're discussing. We've talked about VRI for general spoken language interpreting as well, and they said, we should look to ASL interpreters to see how they work with the video remote interpreting. So our standards are there and established for spoken language interpreters. Now, the American Bar Association also says they would prefer having a live interpreter, because when you're using VRI, you can only use it for limited situations, but they do strongly encourage having an interpreter present. But the problem is that sometimes having an interpreter present, not qualified, don't have the skills, can also be detrimental. But if you can get a qualified interpreter through video remote interpreting, that's a much better resource. So those are some of the things that we need to consider as we look at these standards. There's an important quote from an important group of people. The people are the Conference of the State Court Administrators. And they run the state court proceedings. And they said that the most wonderful, newest language technology that's being fostered for language access is video remote interpreting. So the state courts are recognizing this, and then from that are setting up the appropriate programs to foster this. I will also talk about some advantages and some disadvantages for using this video remote interpreting. When you can use it and when you can't. It's not definitive, but we should develop some standards. There's no right answer, but I can give you some ideas of what the courts are thinking about. Well, of course, safety is an issue. I'm not so was it safe? It's safer to leave Ted in Sacramento than bringing him to New Jersey. And of course, video remote interpreting is also something you can retain as record. Also, if you have the courts too far and remote, you can share the interpreting through a call center. Ends up being less expensive. And if you don't have enough interpreters, it makes sense if they're all in one place, they can make these calls to the different locations. Now, hospitals already share pools of interpreters, so that's one option, depending on what state you're in and what language is being used. So if the cost of interpreting services is 50%, 50% of the cost is spent for travel and then also for cancellation fees without prior notice. So again, for court with limited financial resources, and then the Department of Justice is now saying, 50 states saying we're not providing language access, even for spoken language. Again, because with the criminal cases we've had, the Department of Justice is saying we have to be accessible to all of the various types of language in cases. And so there's a definite undue burden on finances for these cases in courts so they can provide equal access. Now, several states have already implemented this process, and I've already explained when you should use it and when you shouldn't. But in looking at these cases, there's one group versus another group, and court administrator's perspective for one group talks about the kind of proceedings that you can use it for versus the type of proceedings you can't use it for. And then if you're looking at the interpreter's perspective and about the client, the deaf client that can use it and maybe would not be used for, it's something that needs to be considered. Now, in Missouri, they use the VRI for the initial appearance, arraignment, and the waiver of preliminary hearing proceedings. And then again, so if a person's using the service, they say, I've done this crime and any sentencing that needs to be involved. If a witness needs to be questioned or cross-examined, you won't use it. Now in Florida, they also use this for probation violation and status hearings. Now in Wisconsin, the next slide, it's more relevant to interpreter's perspective. If it's far, if the interpreter is not readily available or close by, they use VRI, so they use proximity compared to other states looking at proceedings. If they can't find a certified interpreter or if it's very last minute, or maybe an interpreter has a conflict with the client and they can't interpret neutrally, a conflict of interest is present, or if a deaf person just shows up and just wants to talk to the clerk or fill out some paperwork or get protection from possibly somebody that may be abusing them, they can walk in. Those types of situations are situations which you can use video remote interpreting. Now there are some detriments because it's 3D and you lose some of the affect. It's 2D, and if it's not working, the technology's not working because you can't figure out how to turn it on, or the technology is not reliable, or it's hard also for turn taking if the interpreter needs to interrupt, get clarification. It's very difficult to get someone's attention, and again, it's hard to take turns. If the interpreter can see all of the people in the room, or if the interpreter has control of the camera, that's much better, but without that, it's very difficult. It can be very stressful because it's all new, it's a new technology, so the stress levels go up, and there can be a lot of technical problems. I'll talk about one research and study that took place in Australia. At Macquarie University in Australia. They studied VRI because the courts wanted to use this system. So they studied different situations and various setups, whether the interpreter was in the room or remote. So they tried to figure out the most effective process versus the most ineffective process in the study. Now, RID's standard practice papers say if it's a high-stakes situation or if there are a lot of complicated language issues or very stressful situations, VRI is not an effective mode to be used. Now, the research from Australia studied 5 different tracks in different situations and interviewed individuals involved in these situations. And all of the problems related to technology. One issue was the screen wasn't wide enough or large enough, or if they did have a larger screen, the individual boxes were too small and it wasn't clear, and the technology was not always fast enough, and they found the screens to be freezing up often. We don't know if there was any errors made, if the deaf person sometimes signs slow because of the use of technology. It influences the deaf person's ability to be fluent or to be comfortable. It's also difficult to get somebody's attention, again, and the turn taking was affected. And in terms of prepping and talking with the client, again, most of these issues were related to technology. However, you can, as an interpreter, make some recommendations if you want to use VRI and to look at all of the considerations of using it. And of course, after the discussion, I'm hoping that we come up with new ideas. Again, the study that occurred in Australia recommended that the deaf person and the interpreter be together. And first, they said not to use VRI at all. But the Superior Court said that we want to use this technology, but the recommendation was that the interpreter and the deaf person be in the same location. So then we rated the models, VRS being the last one. Again, having the deaf person and the hearing person together was first. The second was the deaf person being in the court and the interpreter being remote, or the interpreter being at the courthouse in a video relay service call being used remotely. Now, Florida has standards in place, and they said they're not allowed to use VRI in various cases. One being if there's several deaf people, if someone's going to say they admitted to breaking the law, if they're using evidence. As lawyers, we call this demonstrative evidence. If there's pictures, per se, if there's models, if there's something that's going to be demonstrated, the interpreter needs to see this. So that when the attorney presents this to the witness, the interpreter actually needs to be there and present to facilitate that piece of the proceeding. Just like with recordings, if the interpreter is in another room and they have to listen to a recording that's going on in the courtroom, it's very difficult to do. And the same goes for any images. So in those specific cases, from an interpreter's perspective, or if a deaf client has a mental illness or any other additional disabilities, it's not recommended. This is in Florida. If the deaf person's under the age of 18, again, it's not permitted. And they have possibly are taking medication or they are disoriented, and then in that case they would not use VRI. Now there's consumers that are deaf-blind, of course. In Florida, it says you cannot use the video remote interpreting if you have a client that's deaf-blind. Now in Wisconsin, they do have standards on when not to use it, not to use video remote interpreting if interpreters available close by, to have the interpreter present. If there's going to be a long period of time of interrogation, questions and answers, again, it's not permitted. The length of it needs to be considered, the type of discussion, debate. In Wisconsin, they state the length being any longer than 15 minutes. If it's going to be complicated, if they have a lot of people involved and they're talking about evidence and hearings and you're questioning witnesses, it would not be permitted. And it would also not be permitted for trials. RIDs, standard practice papers, and others have talked about the various considerations to think about where we should not be using VRI. If the interpreter find themselves having difficulty establishing language with the client, or juvenile cases, or mental illness cases, or if this deaf individual has never used an interpreter before, and then having the technology on top of that, it would not be recommended. Or people that are deaf-blind, close vision, or have any difficulties with language in general. Now, maybe thinking where these standards come from. These courts create these particular standards, which could be good and bad, because sometimes interpreters are involved in these committees and other times they're not involved. As you can see in Wisconsin and in Florida and in Missouri, obviously they have interpreters involved in these committees because the standards talk about issues related to interpreting and the interpreting field. But most court administrators are not familiar with interpreting issues. And where's the deaf voice? I have not seen any of these committees, the AOC, the Administrative Office of the Courts, the AOC's committees involving deaf individuals, and of course they should because they are consumers, and then consumers have opinions, and they have opinions related to these legal issues. I also just read an article in the Baltimore Sun where they interviewed a patient from Johns Hopkins University in Baltimore, where the doctor actually was in one office and the hospital had a robot in the office. The doctor remotely, with a remote controller, controlled this robot. And the robot's face was a TV screen, and the patient had this robot in front of them with the head being a TV screen, with seeing the doctor remotely, and the doctor did all this questioning. It was very nice to have that quick contact. However, this patient wanted the doctor to be there present in the room. And the patient asked the doctor how they liked this technology, and the doctor loved it. So the patient or the deaf consumer needs to be involved in these decisions. And the courts also can make a decision on their own because they're spending the money. So ultimately, it is a court's decision, but they should also seek consumer opinion. So the standards should be related to those considerations. However, we can't forget the legal interpreting rules. How interpreters can talk to the attorneys. There has to be a way that they can turn the VRI off, and then the attorney would have to wear a headset so they can hear the interpreter, hear what the interpreter's saying, and interpreting from the deaf client. The interpreter has to be able to see the deaf consumer, and the volume has to be off so the audience doesn't hear it. So the interpreters still have to take oath. They have to still do the voir dire, talk about their certifications. If anything needs to be disclosed for the record, they still need to do that as well. If they do a full voir dire, they have to be prepared to answer questions. If there's an interpreter involved, they have to be able to work all of this out. If an interpreter needs to send a portfolio in beforehand or email portfolio in because they're working remotely, those are some of the considerations that have to be made. It's also going to be recorded, and that can be recorded. However, you have to make these preparations in advance. Also, for prep, it's unlike VRS. You have to be able to read the case. You have to understand who's filing the case, and the interpreter still needs to be prepped well in advance of the case. Also, the interpreter needs to see the evidence. If you're talking about a criminal case and you're specifically talking about a weapon, the interpreter has to see the weapon, and the interpreter must be fully aware and knowledgeable. So if there's any clarification that needs to happen or sharing of information, that has to be discussed and developed prior to using VRI. And again, the turn taping is also an issue. If the attorneys are having their own discussion and it's a very quick, rapid discussion, that's very difficult. So you have to put these agreements in place prior to the proceedings taking place as part of the protocol to this. So in Wisconsin, they have discussed the criteria, and with VRI, they've talked about the procedures that they take before they get into this. Before this actually takes place, you have to make sure the interpreter is qualified, there's no conflict of interest. You have to make sure the interpreter and the deaf client understand one another, that the language is suitable. Make sure that the noise level is bearable. Make sure that the screen is clear and who controls the camera. And to have the interpreter actually test the camera, make sure that it needs to be moved. Again, the sound and video checks need to be done. The interpreter needs to get all the prep information, the charges, the documents that should be emailed or scanned to the interpreter, and make sure that they have time to meet with the deaf consumer so that they understand one another, and also for the interpreter to explain their role, as well as meeting with the attorney, getting information about the case and explaining their role as well, because all of that is still very important and still go back to our legal proceeding protocol and rules. Now, when you arrive to the location and you turn on your video screen, you still need to make sure that this interpreter's voir dire, that the interpreter can see clearly and be heard clearly. And the judge and the attorney should also speak clearly and loud enough and take appropriate pauses in between their thoughts and not speak on top of one another and overlap. So it is the interpreter's responsibility to be sure that people are following this protocol. If they're using a microphone, sometimes what happens, people start moving paper and the microphone is then picking up all of the ancillary noise, and that's very distracting. So you have to discuss different technology and different pieces to it. If you're catching everyone's voices through a laptop, it's very difficult, especially when you have a group of people that are not close in proximity to the laptop, where you actually need to be for the interpreter. And what they did in Wisconsin is introduce themselves, share their name before they speak, and then they use consecutive interpreting to be sure it's accurate and that there was no omissions in the information. So clearly Wisconsin has interpreters on this committee because they have thought through thoroughly how to make this process as effective as possible before the proceedings as well as during the proceedings and well after. So again, my question in 2024, interpreting, including technology, is going to be different. Where are we going to be? We need to have a grasp of technology and access. Are you going to be interpreting from the beach? And I hope you've enjoyed this symposium. I hope that you've enjoyed the discussions, and I will be there June 4th to discuss this more with you, and hopefully together we can make sense of all this new world of video remote interpreting. Thank you.